Well, good afternoon, everybody, and welcome to number 7 in our series of WebExes on COVID-19 and employment issues. Jen and I were just having a chat briefly before we started today, and I said to her, this is the 7th one, and Jen said, only the 7th. It feels like a lot more than that. Yes, this is number 7. I anticipate, I'll say this in advance, for those of you that have seen the new job retention scheme, you'll have seen that the proposal is to issue more detailed guidance on the 12th of June. So as a date for your diaries, I expect we'll be doing our 8th session on the 16th of June, so the Tuesday following the publication of those more detailed guidance. I don't know what it is about the Chancellor that he decides to always publish these updates and guidance about 5:30 on a Friday night. I don't know about the rest of you, but in our team we have fun time at 5:15 on a Friday, and it's often disrupted by the Chancellor and his announcements. So, although I have to say, as a group of employment lawyers, I think we get quite excited when that happens and interrupts our fun time. Would you say that's right, Jen?
I think everyone's just sitting there thinking, I can't imagine anything less fun than fun time with employment lawyers.
Well, that you're perhaps right. Now, there is a key update this week. I've kind of got a list of things where I was going to say, well, these are all the things that have happened since our last session on the 15th of May. I think the main thing that's happened is I have discovered on Zoom, apparently, there's and it sounds a wee bit dodgy perhaps, a touch-up facility, which basically means if you press the button, you apparently look 10 years younger on the screen because they smooth over your appearance, etc. So I did suggest to Jen and to Emma, who helps us out in the background on these sessions, that perhaps there might be a similar button on WebEx, but Emma said to me that she reckoned everybody would notice if Jen and I suddenly looked younger. So apparently there's no such button on WebEx, sadly. And I also was saying to Jen, I expect we probably look 10 years older rather than 10 years younger. Having gone through these various webinars and furlough schemes, etc., I expect there's quite a few of you on the call that feel very similar. But anyway, on with the content of today. So, as I say, a number of developments since our session last time, which was around about 2 weeks ago. In terms of the Scottish landscape, of course, someone just posted that the touch-up and digital background functions are a miracle. I feel we have to look into that further, Jen. In terms of the Scottish landscape, as I say, we've had the Scottish route map published, which obviously sets out the process from here in terms of gradual easing of lockdown. Obviously, there's been a lot of controversy and comment on the fact that the Scottish route map is slower than the English process, and I'll come on to touch on that later on. We've also got the Test and Protect scheme launched in Scotland and a similar scheme in England. The government, the Scottish Government, towards the end of last week, beginning of this week, has started publishing specific guidance for each sector on what opening up looks like. It's very similar to the guidance that was published a couple of weeks ago by the Westminster Government. So they're the kind of key updates from a Scottish perspective. We've had an amended Treasury Directive issued, which does clear up a couple of points, leaves one point still not completely clear, which I'll come back to. We've had amendments to Statutory Sick Pay, and Jen's going to pick that up. But the key one, of course, is the Chancellor's announcement on Friday, where the kind of future for the job retention scheme was made a bit more clear. As I say, the Chancellor did say that there would be more detail released on the 12th of June for that, and we'll kind of chat through that in a moment. So what's the purpose of the session today? Well, I'm going to cover off the job retention scheme and the Treasury Directive. I'm then going to pass to Jen. Those of you who were on the session last time will remember Jen did a kind of useful list of 6 topics or 6 categories of employees, if you like, in relation to returning to work and what the issues are there. We thought we'd do a quick recap on that today, because I expect more and more of you are dealing with or starting to think about issues about employees returning to work and what your options are. And then Jen's also going to look at the changes to the statutory sick pay provisions. And then I'll just finish up on the back of that with a few points just to highlight to you. So without further ado, let's get going. So on the job retention scheme, I guess the first thing to highlight to you, if you've not already seen it, is that when the Chancellor made his announcement on Friday, the government also issued a fact sheet for, well, it covers the self-employment income scheme, but it also covers the coronavirus job retention scheme, and it sets out a fair bit more detail, obviously, than what was in the announcement itself. So just to say to you, if you haven't seen that, it's certainly something worth taking a look at. And I think actually perhaps what we should do is when we send an email at the end of the session with the recording, we can maybe attach that as well, just to make it easy for you to see that. I'll kind of chat through the key points that come out from the fact sheet and the key changes. I suppose the first one, the issue that's had most coverage really is the adjustments to pay, which I'll come on to. But before we get to that, I think it's really key to flag this provision around about who can qualify for the new job retention scheme when it comes into place. So the fact sheet talks about, and the Chancellor kind of hinted at this on Friday when he made his announcement, what the fact sheet states very clearly is that only employees who have been previously furloughed for a minimum of 3 weeks by the 30th of June will be able to access the furlough scheme from the 1st of July until the end of October. Okay, so if you think there's anyone within your organisation who you may want to furlough between July and October, but who has not been furloughed yet, then really you've got a deadline of the 10th of June to get them placed on furlough, because of course they'll have to have their minimum 3-week furlough period by the 30th of June. So just something to think about in terms of your planning, and if you're looking at rotation and if you're looking at people returning to work, if you want to maximise your flexibility there, you need to make sure that anyone that you want to furlough with effect from the 1st of July has already had at least one 3-week period of furlough prior to that. Now, they don't need to be on furlough as at the 30th of June. All you need to be able to demonstrate is at some point between March and the 30th of June, the individual has had a 3-week furlough period. Okay, so quite an important point to note. Yeah, Jen.
We've had a question in already on that, and you may be coming on to cover it, but I just thought I'd flag it to you now. If someone's been furloughed prior to the 10th of June, can they continue to be rotated in furlough with another employee? Is there any change to that, or is it just that guillotine point where you have to have had a period of furlough before the 10th?
Yes, it's a really good question. You can still rotate furlough. There's no, as the fact sheet indicates, you can still rotate furlough. There's no prohibition against doing that. Obviously, we'll need to see what comes out on the 12th of June, but I don't get the sense that's going to be an issue. I think what will come out on the 12th of June is more around about the part-time working point, which I'll come on to in a moment. So you can still furlough. Once you put people on furlough from the 1st of July onwards, you can still rotate that furlough as long as the individuals have had that 3-week period prior to the 1st of July. The other key change on that is that 3-week minimum period is no longer going to apply. So with effect from the 1st of July, the minimum period for furlough has to be 1 week at a time, which will obviously then, again, give you a lot more flexibility in terms of rotation if that's a process that you look at and it's a process that you're looking to use. So that's the first point. The second point is round about part-time working. Of course, there was a lot of pressure on the government to look at removing the rule that you could only go on furlough if you carried out no work whatsoever for your employer. And I think very sensibly then the government have said, okay, from the 1st of July right through to the end of the scheme, and you'll have seen, I'm sure, that the scheme is now, we've been told it's going to end at the end of October, you can allow people to come back to work part-time so that they're at work some of the time, they're furloughed part of the time. So the example that's given in the fact sheet is, you could bring somebody back to work for you for 2 days a week and they could be furloughed for the remaining 3 days of the week. And the furlough scheme will cover their normal working hours. One point, I guess, to note on that is the original intention had been that would come into effect from the 1st of August, but the government have brought that forward a month to the 1st of July. I expect part of the reason for that is so that it ties in with this move towards reopening of businesses. And again, it kind of ties into this point about Scotland and England being slightly different from that point of view. But certainly, when you look at the dates in terms of when shops, etc., are due to open in England from the middle of June, I think probably they were quite keen to introduce that ability to do part-time furlough a lot quicker. Again, we don't have any detail really about how that will operate in practice. One of the questions that comes to my mind is that's fairly straightforward for people that you have working normal hours and you know what they work every week, and that's quite clear. The challenge will be for those who don't have set hours, or for those that do variable hours, how you work out what their normal working week will be. And it may be that it's based on kind of similar rules round about working at an average over previous 12 weeks, etc. We don't know yet. And that's something that we anticipate is going to be set out in more detail when that further guidance comes out. The other thing to note, and it wasn't immediately clear to me when I first looked at the fact sheet, but then there is provision in it that states, I'll just bring it up in front of me here, when it talks about the £2,500 a week cap, it does say the cap will be proportional to the hours worked. So if you have someone who is working 2 days a week and they're furloughed 3 days a week, then they'll be entitled to 80% of their salary, or 3/5 of £2,500 as a maximum cap per month. So something to note there. I suppose the other thing in terms of part-time working is to think about, and it will depend where each of your businesses are in terms of cash flow and the urgency and the need to save money or not. But there's a bit of commentary around about, well, if you bring people back to work, say for 3 days a week, you still, of course, have the option to agree a pay cut for them for those 3 days. So, you don't necessarily have to bring them back and pay them 100% of their salary for those 3 days. You could reduce their salary if there's a need to do that. You would, of course, have to get the employee's agreement to that, so you would have to consult with them, you'd have to get them to sign up that they're happy to accept a reduction in their salary, but just something to think about when you're looking at flexibility and what you put in place for the individuals when they return. One point that, again, Jen and I were having a chat about just before the session, it looks like possibly the fact sheet goes a little bit further than the existing job retention scheme. So you remember there was a kind of controversy for a short period of time in relation to the existing scheme when the Treasury Directive was published, and it seemed to indicate that in order to qualify for the grant, you had to make sure you had the employee's written agreement to furlough. And I remember that week, Jen and I panicking and thinking, oh my goodness, how many people do we need to phone to say, well, potentially you need to have written agreement. And then that was challenged, and then subsequently the Treasury Directive has been amended. The Treasury Direction has been amended to say no, you don't need to get written agreement to placing people in the job retention scheme. What the fact sheet says, though, in relation to the period from the 1st of July onwards, and again, if I get the wording up in front of me here, I'll read it to you. It says, to be eligible for the grant, employers must agree with their employee any new flexible furloughing arrangement and confirm that agreement in writing. So it seems to be indicating that if you're looking to move people onto part-time working from the 1st of July, so they're with you part of the time, furlough part of the time, that you have to agree that new flexible working pattern with the employee, and also that you have to confirm that agreement in writing. So it seems to go a bit further than the existing scheme, where what you have to do in writing is confirm to the employee that they mustn't carry out any work whilst they're on furlough. Now, the discussion Jen and I were having was, is that a deliberate change to the scheme where HMRC and the government have realised they can't retrospectively apply that obligation to get written agreement, but for the new scheme from the 1st of July, because they're effectively calling it a new scheme, do you have to get the employee's consent in writing? Or is it just another example, and we've seen this quite a few times with the Treasury Direction and with the guidance, is it just another example of kind of clumsy wording, and that's not really the intention? So I guess it's just something we'll obviously see as things develop on that and as commentary develops on that, but I guess it's just something to be aware of. Of course, you've got your normal employment law obligations anyway. If you're looking to bring an employee back to work part-time, you would need to change their contract. You would need to get their agreement to that. If you're saying to them, well, we don't want you to work 5 days, we just want you to work 3 days for a permanent make that a permanent change or for a short duration, whatever. So best practice would be to get agreement anyway, but just to flag to you that seems to be a slight change in emphasis when you look at the wording of the fact sheet. I've said to you already, you can claim now for 1 week. It doesn't have to be for a minimum of 3 weeks, so I think that's helpful. Another provision to be aware of, again, this is in the fact sheet and wasn't in the announcement, from the 1st of July, the maximum number of people you can claim for in any claim cannot exceed the maximum number of people you claimed for at any time prior to the 1st of July. Okay, so if you put in a claim, say in April for 20 people, in May for 25 people, and in June for 30 people, from the 1st of July, the maximum people you could claim for in that scenario would be 30 people, because that's the maximum you claimed for under the existing scheme. And I think that's quite important, because you might find, or you might look to furlough more people where it's a week at a time, and it may be that your numbers are in excess of the 30 quite quickly. So just from a practical point of view, thinking about or making a note of, under the existing scheme, what is the maximum number of people you've claimed for, and making sure you don't exceed that in any future schemes. I can just imagine now people thinking, oh my goodness, well in June then I better furlough as many people as I possibly can to give me that extra flexibility, but just something to be aware of. Another point, again from a practical point of view, the fact sheet is clear that you cannot claim for overlapping months with effect from the 1st of July. So under the existing scheme, you can choose when you put your claim in. It's obviously meant to correspond with your payroll process as much as possible, but claims at the moment could cover, part of April and part of May, or part of May, part of June, etc. The scheme, the fact sheet says that for claims under the new scheme, you cannot claim overlapping months. So you should be putting in one claim for July, one claim for August, one claim for September and October. So again, just another practical point to note.
On that, like in that practical example, if you started someone's period of furlough in the middle of July and it lasted 4 weeks, so it was straddling 2 months.
Yes.
It's still okay, but you can only claim for 2 weeks in July and 2 weeks in August.
Exactly that. Yeah.
You have to have any furlough just completely contained within 1 month.
No, it's fine. Your furlough period itself can straddle over the months, but your claim has to relate to the month that the furlough took place. So, and there's also a transitional provision in there in relation to any furlough where people have been on furlough for June. You can still claim June furlough payments. I think it's up to the 31st of July. So you're able to do it for that month. But as I say, just to be aware from a practical point of view going forward, it has to be based on set months. I'm loving your questions, Jen. You can tell Jen's been on holiday. Jen's using this as an opportunity to catch up.
Someone else asked, as well, we were just finishing off the point about collective bargaining and collective agreement. Is that still presumably a permissible way of getting agreement in accordance with employment law? Yeah.
Absolutely. There's no suggestion that that's going to change. So collective bargaining should be absolutely fine. Yeah, that's no problem. And I see there's a question there about, does the training exemption to no working furlough still apply? Yes, it does. Does the exemption apply to trainers as well as trainees? If you're trainers, well, it depends. If you're trainers, I think that's more likely to be viewed as work. If they are training people and that's their job, that's what they do, I don't think they will be exempt. And potentially, are they creating income for your organisation? Probably not, but it is still their job, which I appreciate makes things very difficult then, because you may say, well, how can we do training if we can't have trainers? But I think that would be a challenge. I think that would be viewed as working. Just on the amounts then, this is you'll all be familiar with this, I'm sure, because it's the bit that's attracted most coverage. Interestingly, actually, I think it's more generous than a lot of people anticipated the new scheme was going to be. There was a lot of chat up until I think probably Thursday evening last week that it was likely to be an immediate change with employers paying 40% and employees paying 40%. Employees, HMRC paying 40%. But obviously it's a fair bit more generous than that. So in July, the situation is just going to stay the same. HMRC will cover up to 80%, including employer national insurance and employer pension contributions up to the limits that are currently in place. From August, the only change is that employers will be asked to pay employer national insurance and employer pension contributions, and then September the employers asked to contribute 10% of the 80%. October the employers asked to contribute 20% of the 80%. Somebody did ask me if there was an option then just to pay the employee 70% in September and 60% in October, so there was no obligation on the employer to top up the amount. The answer to that is no. The scheme is very clear that employees will continue to receive 80% until the termination of the scheme at the end of October, and that there's an obligation on the employer to pay that top up. So if you don't pay the top up, you won't get the grant effectively. So that's the figures, which I'm sure you're all very familiar with. One point I wanted to make in relation to key dates, so we've already spoken about if you've got anyone that you think you'll want to put on the scheme from the 1st of July that hasn't previously been furloughed for 3 weeks, you need to start their furlough period on the 10th of June, so that's date number one. The second date that is going to be really important for you to take a note of is the 16th of June, which of course is 45 days before the end of July. So if you are looking to make 100 or more staff redundant at the end of this existing furlough scheme, or at the end of the period where the government's paying the full 80% plus NI plus pension contributions, those redundancies are likely. You might want to look at those redundancies taking effect on the 1st of July, which means you would need to start your collective consultation period by no later than the 16th of June. So I don't know, Jen, are there any other questions have you picked up there just on the chat in relation to the amendments up just now before I go on to the Treasury Direction?
No, there's a couple of questions actually on calculating pay, and I think as you said at the start, Morag, they are going to be complicated for atypical workers, frankly. So we've had a couple of questions on part-time working and 0 hours contracts. I don't think it's right for us to kind of go into detail on that at the moment, because those are the sort of questions where you actually need to get your head into the guidance note that, remember in the last webinar we mentioned that HMRC have produced, I think it's now something like 6 or 7 different dedicated guidance notes or web pages, and there's one about calculating what the 80% is for that person. So I would just recommend going on that, because I think it will be fairly complicated for atypical workers. Yeah,
that's a really good answer, Jen.
I don't think any restyling on how to calculate 10%,
or quite
80%, right?
Right, absolutely. There was another question actually that came in to the session that I just wanted to pick up at this stage about, it doesn't really relate to the changes to the scheme, but it's just a question around individuals who are currently on furlough. And the question relates to that special category of shielding. So if you've got an employee who's shielding, but you need the work to be done, and so you look to bring in a contractor or someone to cover their workload, can you still furlough the person that's shielding because their job needs to be done? And the answer to that is yes, you can, because you'll remember, I don't know how many sessions back it was, but when we spoke about when there was quite a change to the scheme, where it specifically said that individuals who were looking after children and also individuals who were shielding could be placed on furlough, and there wasn't any requirement for you to show that they were being put on furlough because they were at risk of redundancy or anything like that. So you can keep someone in that situation on furlough and bring someone else in to cover their role. That's absolutely fine. So I'll move on then just very briefly to touch on the amendments to the Treasury Direction. The timing of the Treasury Direction being amended it always feels really clumsy. It was amended last week when they must have known that the new scheme was going to be announced on Friday. You would think in some ways they would try and do the two things at the same time, because you then have a Treasury Direction that's out of step with the retention scheme. But we are where we are, and I expect we might have another update to the Treasury Direction around about the time we get the update to the new scheme. It's clarified, I guess, a couple of points. There was a bit of doubt about, because of the way the Treasury Direction was worded, could you take someone who was off sick and on SSP? Could you take them off SSP and them on furlough? The guidance seemed to suggest yes, you could. The Treasury Direction, it wasn't quite so clear. So that's been clarified. Yes, you can. If you've got someone who is in receipt of statutory sick pay, an employer can take them off the sickness absence period with their agreement, obviously, and place them onto furlough. The other point that was clarified a bit, but I suppose given what I've just said about the new scheme, be thrown into doubt a wee bit again, but I've referred earlier to the fact that when the Treasury Direction came out, it seemed to suggest that you had to get written agreement before you could place anyone on furlough. The wording of that has been changed in the Treasury Directive, so we're a lot more comfortable that you don't need written agreement, and it was just clumsy wording. But do remember what I've said about the fact sheet for the new scheme, where it seems to suggest that you do need that agreement in writing. I think it's just a point we need to keep an eye on. The point that's still a bit unclear in the Treasury Direction, and I'm just going to touch on it very briefly because it will only apply to a limited of people, I would imagine, but it's this question of whether someone who was on unpaid leave could be placed on furlough. So the job retention scheme, the guidance note is very clear. It basically says if someone was placed on unpaid leave after the 28th of February, then you can furlough them. If they were placed on unpaid leave before the 28th of February, you can agree a return date with them and then furlough them. The Treasury Directive is a bit contradictory because it says if you place someone on unpaid leave before the 1st of March, but you agreed a return date with them before the 20th of March, you could then furlough them. But then later on it talks about you can't claim furlough for someone who was placed on unpaid leave between the 1st of March and the end of June. So it's still there, it's still a bit clumsy, but I think the view that we've taken is generally you can, as long as the person falls within the confines of the guidance note about when they were placed on furlough leave and you agree in a return date, that you can place people who are on unpaid leave onto furlough. Okay. Again, Jen, is there any questions that it would be helpful, do you think, to pick up here before you go on to talk about the different categories in the SSP? I don't know if there's anything else that's come in that would be worth picking up at this stage.
Another question's come in, something that we've covered on a couple of other webinars, but I think it's an interesting point. You touched on the 45-day period, Morag, for collective redundancies, and whether or not you can claim under the furlough scheme for notice pay during that period. Our view on that is there's nothing in the scheme, or there's nothing in the guidance note that would prevent you from doing that, because it is wages. It's technically notice pay, but if they are still employed by you in relation to that period, they are wages that are being paid. And there's reference in the guidance note to employees to say you can be made redundant while you're on furlough. It's very clear that you're not able to fund statutory redundancy payments or indeed contractual redundancy payments through the furlough scheme. That would not be possible or appropriate, and I don't think anybody would ever really think that would be appropriate unless you were really being abusive in terms of the way that you use the scheme. So it looks to us at this stage as though that is permitted. I think what Morag will come on to talk about though is that there seems to be quite a lot of reputational buzz around timings, and you see it on both sides. It's a question of, do you have an obligation to keep people on furlough and not terminate their employment for as long as the scheme is open? The flip side being, is it wrong to have people on furlough when you know you're going to make them redundant, and should you therefore just be going through that process as soon as you know that's happening rather than claiming under the scheme? So I'll let Morag kind of talk through some comments that have been in the media on that later, but on that notice pay point at this stage, there's nothing in the guidance which would appear to preclude it.
Yeah, I mean, I'll pick up that point just now actually on redundancy and people that are placed on furlough. You may not all be as sad as I am, but I was listening to the liaison committee last week when Boris Johnson was being subject to questions about COVID-19, and one of the questions that he was asked was exactly this point, and it was in the context of British Airways, and you'll see they've received a lot of press coverage last night and last week. But the question was asked, is it right that employers can, when they know that they're going to make redundancies, that they can keep people on furlough until they carry out the redundancy process? Is that fair? And Boris Johnson's answer to that was he thought it was a very important issue and it was something that they were looking at, which I think was kind of consistent with a lot of his answers, to be fair, to the liaison committee. But when you look at the original version of the job retention scheme, as Jen says, really, it had provision in there that said, for example, if someone redundant, you can take them back and put them on furlough, and you can claim a grant for it. So that was, very clearly allowed to be covered under the job retention scheme when it was first put in place. I think what is happening now is there is a bit of buzz and conversation around, well, is it right that certain companies have used furlough? Should they have done that? Should they be revisiting it now? And is now a good time to revisit it in light of the new scheme coming into play? I saw an article this morning actually which was really interesting. The Spectator editor published a letter to say, it was Spectator, Jen, was it? I think, yeah. To say that they had applied for the grant and placed a number of employees on furlough when this all started, but actually their sales, their online subscriptions, they've performed better than they anticipated they would through the COVID-19 lockdown, and therefore they've now taken the decision to repay the grant that they've received from the government. And it's quite a nice PR exercise. It's a nice message to get out there when there's quite a bit of controversy about other companies that have used furlough, and also from a point of view of people thinking, oh, what a decent outfit they are. I think I will subscribe to the Spectator. So there is a lot of chat about it just now. The other thing I would say is I have seen commentary that Unite are saying that they will refuse to take part in any redundancy consultation process when employees are on furlough. I don't know how widespread that is, but just to flag to you, there's a bit of agitation round about that issue. Okay, I'm just going to quickly check if I had anything else on furlough before we go, Jen.
Yeah, no, I was just going to say that I think, just in the same way as the government is sort of, as Morag says, framing this second phase of the furlough scheme as a new scheme, I think as organisations, it's probably an opportunity for you to now reassess your use of the scheme. So, my view would be phase one was the critical survival phase, and actually the plea from the government at the start of that was, don't make anyone redundant, just keep them on your payroll or bring them back onto your payroll and we'll look after them. The tone and the messaging is changing, so I think for anyone who's feeling that pressure either from a reputational point of view or from an internal employee engagement point of view, I think you just want to maybe test your use of the scheme going forward into this second phase and decide whether anything has changed or if you have any sort of feelings of uncertainty or discomfort about your use of it. But I do have sympathy with a lot of employers because they're getting pressure on all sides, and I think by and large what we've seen is employers are trying to do the right thing by employees to give them, keep them in work as long as they can, while still recognising that from their own financial point of view, retaining them in the workforce may not be possible, and that is actually why they put them on furlough to begin with. So not an easy question to answer at all.
There's two more questions I'm just going to pick up then, Jen, before I promise I'm going to hand over to you. The one there about if the intention is to commence part-time working in July, can furloughed construction workers be involved in site preparation for return to work during June? No, I'm afraid not. If they're on furlough, they'll not be able to carry out any work, so they won't be able to help with site preparation. And the other one I wanted to pick up, which is coming through the emails prior to this session, is this question again about public funds and furlough. So we're being asked just again about, if you've got people that are in receipt of public funds, can you place them on furlough? And what we've been saying before, and apologies to those of you that have heard us say it a few times, but what we've said before is, if you're in receipt of public funds to pay for an individual's role, then you shouldn't be furloughing them, because the guidance says that you're not expected to place people on furlough whose roles are being paid by public funds. There's of course this whole issue about, if you're a charity, how do you identify whether funds are specifically to pay for someone to carry out their role or not. But I suppose just by way of an update on that, interestingly, this morning there was a news article to say that the SNP ministers are encouraging public bodies in Scotland to apply for furlough. And the kind of view that's been expressed there is, when you've got individuals working for your organisation and you don't have specific kind of funding assigned to their wages, then potentially you can place them on furlough. Now, I don't know if it's a political point that's been made there or not, but it was quite a surprise to see that this morning, that that's actively been encouraged by SNP ministers, where you've got public authority and they're saying to them, you can use the furlough scheme. And I suppose on that as well, and I said I'd come back to this at the end, but I may as well touch on it just now, there is this issue about, and again this was a question that came in prior to the session, this issue about Scotland and England coming out of lockdown at a different pace. So is the new scheme drafted really on the basis of the English lift of lockdown? So, allowing people to work part-time from July, ending the scheme in October. And Nicola Sturgeon was specifically asked this question at the press conference yesterday, and what she said on that was, well, our easing of lockdown is slower than in England, and therefore we will need the furlough scheme for longer, potentially. And so we're asking the Westminster government to reconsider that. And if they don't, then we might have to ask for further borrowing so that we can implement our own version of the furlough scheme effectively. So again, there's a bit of politics, I imagine, going on there, but just to be aware that that's an issue that's attracting a bit of coverage at the moment as well. Right, Jen, are you ready? This is your moment. Jen, as I said, is just going to quickly recap on those categories she spoke about last time, and then an update on SSP, Jen. On you go.
So I think a lot more of you are now looking at people imminently returning to work, and no doubt getting a lot of questions as well from staff who are anticipating that request coming out. Certainly the position always remains the same. If you can work from home, then that is still the preference. And I think that's sometimes lost in the buzz of, what do you do if you don't want to come in? What are your entitlements? What are your rights? What are the risks? So if people can work from home, then they should work from home. But if they can't, then these are the categories that we've kind of bundled people into. First one is the easy one, well, relatively easy. People who are happy to come back to work. For that category, you're just making sure that you, from a health and safety perspective, have undertaken all of your appropriate risk assessments and put in place appropriate measures at work. And I say that as a sort of side comment, but actually we all know that's a webinar in itself, isn't it? And that's a massive undertaking to adapt your workplace to make it as safe as you reasonably can at the moment. In terms of people who are reluctant to come to work, you may have a category of employees who are saying that they can't come to work because they're caring for someone who is extremely vulnerable, or they're caring for their children and the schools and nurseries haven't gone back yet for them, and so they can't come to work. In that sort of situation, just as Morag was touching on, for the extremely vulnerable category, the guidance that we have still gives the option of furloughing those people. So that kind of status furlough we spoke about right at the start, where they cannot come to work to do their job and they can't work from home because of their responsibilities, it's possible then to keep them on furlough. But the other options you might look at are then taking holiday, maybe a period of unpaid leave, or agreeing some sort of flexible working arrangement. I would just say in that sort of situation, you want to be careful around any indirect sex discrimination risks, because it will predominantly, again, similar to the part-time working case law, be women who are sort of bearing the childcare responsibility. And so any pressure that they are placed to return to work where they're saying they can't because they're looking after children could generate an indirect sex discrimination risk. Third category of extremely vulnerable people, so these are the people who are shielded. I think it's quite interesting, Morag mentioned it earlier, I think it's quite interesting the changes that were announced in England over the weekend to say that they can now leave the house for exercise or to meet one other person. And I did wonder whether that maybe to some extent undermined the justification for furloughing them, because, you know, arguably then could you extend that logic to say they could come to work if appropriate health and safety measures were put in place. I think the position remains the same there. If they are in receipt of the shielding letter and they can't work from home, then I think you can furlough them. But you can, of course, also have conversations with them about, you know, a potential return to work and what adjustments might be necessary. Your real risk there is disability discrimination, and I think you have to operate on the basis that you certainly will have an active obligation to make reasonable adjustments for those individuals. For vulnerable individuals who are not shielding, I think the ability to furlough for them is fairly limited, I have to say, because the public health guidance doesn't preclude them from leaving the house or working. Actually, it just says that they have to operate extremely stringent social distancing measures. That's not to say that you might not agree with that individual, a reasonable adjustment of them remaining at home or doing an adapted role or an alternative role for a while. And I think you have to be very sensitive in the conversations that you have with those individuals. But from a furlough point of view, it's not as clear cut as the extremely vulnerable category that you can use the scheme for them. People that are anxious and hesitant to return to work on health and safety grounds, I won't overcomplicate this. All I would say is stick a pin in that category as being quite a high risk category for two reasons. The first is what you'll all be familiar with, the risk of disability discrimination claims if those individuals say my anxiety or stress condition is actually a disability and you need to make reasonable adjustments for me. The second reason is that what we're kind of calling Section 44 claims are becoming more and more kind of relevant in this context. That's where someone says, I'm not coming to work because I'm really worried about serious and imminent danger from a health and safety perspective. And that might be about their use of public transport getting to work, or that might be actually in the workplace. I don't think you've made sufficient adaptations or taken health and safety measures seriously enough. Or just, you know, they could actually say, I'm just so worried that the R number is still hovering around 1, that even with all the measures that are being put in place, I'm terrified of getting this and then coming home to my partner who has a medical condition that makes them more vulnerable. The test for that is whether they had a reasonable belief of a serious and imminent danger from a health and safety point of view. And the more measures that are put in place to reduce those risks in the workplace, the lower the likelihood of them being able to say it was a reasonable belief. But actually, I still think, you know, we're not past the point where someone could credibly say, I know you're telling me you've made all these changes, and I know, you know, Boris Johnson is encouraging people to go back to work in England, but I just do not feel comfortable with it. I'm really, really worried about it. So in those sort of situations, a bit similar to whistleblowing, those individuals have protection from detriment or dismissal if it's linked to that belief that they had. So a tricky area and just a category, as I say, to be really careful with. On a practical level, regardless of legal risks, I think the key to those individuals, and actually anyone who's reluctant to come back, is engaging with them and consulting with them as much as possible, to try and, listen to their concerns to the extent that you can alleviate their concerns. And frankly, from an organisational point of view, what you don't want is people feeling forced to come to work when they're terrified, because you're not going to be getting good work from them. What you would rather is find a solution that works for you and for them, and then maybe review that in a couple of weeks' time and see how they're feeling at that point. Just to sort of bolt on to that category are those who are happy to come into work to begin with, and then actually, once you've been there for a couple of days, say, I'm out, this is not something that I'm comfortable with. And again, that could be the Section 44 type claims. And we've talked before about what happens if that's because of the actions of another employee. So you've got all these really stringent measures in place. Everyone's been trained on health and safety, and then you have one rogue employee who is, being far too up close and personal, not washing their hands, not wearing a mask, coughing. So, that just underlines the responsibility employers have on an ongoing basis to implement those health and safety measures that they've identified in their risk assessments at the start, and continually monitor that to ensure as much as they can that they're implemented. So the final category in this blends into the topic that we wanted to discuss around SSP, is just this rolling category that I think we're all going to have going forward, of people who are self-isolating for a number of reasons and therefore not able to come to work. And you'll all remember there was the amendment to the SSP regulations right at the start to extend SSP entitlement to people who were self-isolating or who were in the same household as someone who had COVID symptoms or a positive COVID test. And there's all the public health messaging that you'll see still going around to give you an indication of what you need to do in what particular circumstances. That's now been extended to cover anyone who's told to stay at home as a result of the test, track and trace policy that's come in. And I do think we're going to see a lot of that. You can imagine, particularly where households are involved, if there's a positive test result, that people are phoning up to say, I've been told I have to stay at home for 14 days, what are my rights? Well, the rights at that point are now to receive SSP for that period, and it's possible for them to get the self-isolation note online now as evidence of the fact that they benefit from that entitlement. The other thing that I just wanted to touch on, because it's come up a few times for a number of our clients, is this concept of the 14-day quarantine that's coming in. So if you go on holiday and then seek to return and have to quarantine for 14 days afterwards, what do you do with those employees? I'd be interested to know if anyone started communicating to staff what your expectations are in terms of restricting travel. We had actually, I don't know if you remember, right at the start, we talked about, where you had kind of category 1 countries and category 2 countries, and, if sort of trying to say to people you shouldn't actually be going on holiday to these places. I'd be interested to know if employers are now pushing out comms around what individuals should be doing in those situations. But realistically, if you're expecting people to turn up to work and they knowingly go on holiday somewhere, mindful that on their return they're effectively bolting on another 14-day period of absence, which is because of quarantine, I think that will be quite frustrating for employers, frankly. The question of whether or not they're entitled to SSP at the moment is a little bit unclear. We're hoping for clarity on that. it could be that they are caught under the extended definition on the basis that they have to stay at home as a result of an enactment of law. But that legislation hasn't actually, this is a technical point, but that legislation hasn't actually been pushed through Parliament yet. So I think that's probably the way it will go, but other options at that stage are to agree a further period of unpaid leave with the individual or for them to use extra holidays. So that's a bit of a watch this space category, and I would hope that at the next session we'll maybe have a bit more clarity on it for you. So that was everything from me, Morag, unless I've missed anything.
Just two questions, Jen, before I finish up on some of the tribunal stuff. Notice pay and furlough, 80% or 100%?
I think the correct approach, or the prudent approach, is to pay 100%. There's some commentary to say that you can theoretically pay 80% if you're averaging what their earnings have been and they've been on furlough for however long, the last 8 weeks. There are also some really technical provisions under the Employment Rights Act, depending on how long their contractual notice period, that can impact on what you pay. My view and my advice would be that I think the right thing to do is to pay 100% and top that up. And I would say it's a little bit similar to the holiday pay. So, where you're seeking to claim money for something that you would otherwise, have been paying in its entirety yourself 100% pay, I think it would perhaps feel it just would go against grain, wouldn't it, to be the employee's entitlement there.
Yeah, that's the correct answer, Jen. Well done.
Thank you.
And just a question there about, you mentioned a self-isolation note for those who are contacted by NHS in Scotland. Do you know if the same applies in England?
I don't know the answer to that. I would assume, I know that they have the same sort of similar mechanisms in England as well for obtaining the self-isolation note. So I would imagine it would be the same, but I'm not 100% sure.
Perfect, thank you. And then I'm just quickly going to pick this one about, has anything changed in relation to annual leave during furlough? No, there's no indication that that's going to change under the new scheme. So,
that's interesting. One person has replied, me posing the question, what are people doing on the quarantine point?
Yes.
Telling people if you elect to go and you have to quarantine, then that will be unpaid leave or additional holiday, which feels totally fair and reasonable, I have to say. Yeah, I agree. You do wonder who'd want to go on holiday just now to be quarantined for 14 days on the way out and the way back, but I want to go to Nice for a long weekend at the end of July, so I was wondering, does that involve me just staying there for a month?
Not if there's another webinar, no, because you'll need to be here to do it with me. Right, very briefly to touch in the end, I just wanted to pick up on some points on tribunals, and I thought it might be of interest to you. Government analysis was issued recently. They keep an eye on web searches and stuff during these kind of periods. And what they've said is that there's been a real spike in searches for employment tribunal. So people Googling employment tribunal in March and April. And the kind of queries that are coming through are, can I be made redundant if I'm on furlough? Is it right that I can be placed on furlough when actually it's not required? And also this point that Jen's picked up and talked about earlier about the Section 44 claims. So, can I bring a claim if I don't want to return to work? Those sorts of queries. So just to put that on your radar, there's quite a bit of activity there. And I think increasingly as well, we're seeing these interim relief type hearings. So for those of you that are not familiar with that, if I make a protected disclosure, if I blow the whistle and you subsequently sack me in response, and I say, well, the reason you've sacked me is because I blew the whistle, I can obviously bring a tribunal claim for automatically unfair dismissal, but I can also, and it's quite a draconian measure, I can also apply to the tribunal for interim relief. And so what that means is the tribunal have to organise an urgent hearing, ideally within 7 days of my application. And if I can show that there's a good chance, and that's all it is, a good chance that I'll succeed with my claim that I was dismissed because I've made a protected disclosure, then they can require the employer to pay my wages until I actually get to the full tribunal hearing and there's a final determination on that point. Now, in the current situation, which I'm going to come on to in a minute in terms of tribunal hearings, that could be quite a long period of time that an employer has to pay my wages until I get to my hearing. And the sting in the tail is, even if I lose, I get to keep that money. So it's just something to be aware of. And of course, it's in the context of if you've got individuals who are raising health and safety worries, for example, and they're able to say, well, that was a protected disclosure. So a bit more activity in that area. And so just, I suppose, finally on the tribunal stuff, the Presidents of England and Wales and Scotland issued a joint roadmap yesterday in terms of where they see things going in relation to tribunal hearings. What they're saying is for June, it's unlikely any hearings in person will take place. They will do straightforward hearings, so if there's no disputed evidence or there's few facts and it's fairly straightforward, they will do those remotely via video link or whichever technology they're going to use, but no more substantive hearings than that. In July and August, they're looking to do some more simple hearings in person, so the kind of CMD type preliminary hearings or simple points, but what they call standard track hearings, so your kind of straightforward unfair dismissal claims are likely to be heard remotely, but there will be more of that in July and August. September, October, they're hoping to then start doing what they call open track hearings, so ones that are a bit more complex discrimination, for example. They're hoping to start doing a small number of those in person, is how it's expressed in the roadmap. And then in November and December, what they're saying is we'll consolidate and review the situation at that stage and then decide what's happening next. So for those of you that have tribunal claims kind of in that pipeline, that hopefully gives you an idea of when they're likely to progress. Jen, anything else from you? No, you done? Okay, right, well, I hope that's brought you up to speed with where we're at now. As I say, I expect if the Chancellor issues his further guidance when he says he does on the 12th of June at 5:30 probably, we'll have that next webinar on the 16th of June. We'll confirm times and etc. of that for you. We're also going to be publishing our updated note on the scheme today, so that'll go on our website if you want to refer to that. It covers all the points we've spoken about today in relation to the new scheme. And as always, if you want to receive updates, etc., and you're not already signed up to the database, if you just go onto our website, there's a contact section there, and you can sign up to receive our updates. So I hope that's helpful. Nice to see so many familiar faces again, and we'll catch up with you again soon. Take care. Bye now.